much. We have another important item before us, and I appreciate those from that petition campaign waiting very patiently. We're going to have just and hopefully this might be a little briefer, Mr. Carl, overview of what's before us with this item, and then we have an opportunity for the petition campaign to present their views, and I believe they also have a PowerPoint, and we want to make sure we're helping them with that.
Madam Vice President, the second petition pending before this body today is submitted by the Committee for Professional Policing through its chair, Dave Bicking, who is present today. The petition seeks to amend the city charter to require that Minneapolis police officers carry professional liability insurance throughout their terms of service, which, if approved by voters, would become effective 1 year after its passage. The petition was submitted to the Charter Commission on June 13th and transferred to the city the next business day by filing with the Office of City Clerk. The first review of that petition found it to be insufficient in meeting minimum statutory requirements. An amended petition was subsequently filed on July 5, which was found to be sufficient and in compliance with statutory requirements on July 11. At its regular meeting on July 22, the City Council referred the subject matter of this petition to this committee for its review, evaluation, and formal recommendation for action by the full City Council, consistent with the procedural rules of the City Council and subject to the provisions of Minnesota Statutes Section 410.12, Subdivision 4. As I have already indicated in the prior petition, the City Council has a ministerial duty that's provided by state law for the handling of citizen petitions to amend home rule charters. Specifically, petitions that are deemed valid must be referred to the governing body of the municipality, that is the City Council, so that it may fix the form of the ballot question. That's the statutory language. What it means is that it is the duty of the council to determine the language used in submitting the ballot question to the electorate. The statute requires the wording of the ballot to be sufficiently to identify it clearly and distinguishing it from every other question on the ballot. We've discussed the form that is required by statute. As directed by City Council, the City Attorney did draft proposed ballot language, copies of which were posted to the city's website on Thursday, July 28. Copies of that ballot question are included in your briefing materials. They also were made available to the public for this meeting. The draft ballot language prepared by your City Attorney complies with the statutory formatting requirement. As with the first petition, the City Attorney requested that I provide her draft ballot language to the petitioner, which I did via email to the committee chair on Thursday, July 28. As of this morning, I have not received any response from the committee about the draft ballot language prepared by the City Attorney. And
I will just let you know that I'll make sure they did communicate with me, and I have received some comment, and I also shared that with the City Attorney. So I just want to make sure we know that we did get that, and we appreciate the feedback.
For the sake of the viewing audience and those in the chamber who may not have a printed copy of the revised ballot language that's been proposed, I'd like to read that text. The question is, shall the Minneapolis City Charter be amended effective November 8, 2017 to require all Minneapolis police officers to purchase and maintain continuous coverage under individual professional liability insurance policies, such policies to be the primary insurance for the officers and to include coverage for willful or malicious acts and acts outside the scope of the officer's employment by the city, with the city having the option to reimburse officers for the base rate of coverage, but with police officers being responsible for any additional costs due to personal or claims history, and prohibiting the city from indemnifying a police officer against liability in any amount greater than required by state statute unless the officer's insurance is exhausted. Pursuant to Minnesota statutes, the clerk must submit the ballot questions to the auditor no less than 74 days before the election. Again, as a reminder, that date is Friday, August 26th, about 3 weeks away. I've also mentioned that the full text of the amendments must be published in both the Star Tribune and the Finance and Commerce paper, which is our official newspaper of the city, for 2 successive weeks prior to being on the ballot. To be enacted, the ballot question requires that at least 51% of affirmative votes of all those voting on the question are tallied. If enacted, then the amendment would become legally effective and codified 30 days after the election unless a later effective date is provided. In that case, the amendment would be enacted by the voters. The requirement for police officers to carry professional liability insurance would become effective 1 year after the date of the election, which is November 8, 2017. Completes my review of the statutory procedures governing consideration of this proposed amendment. Again, it's the duty of the council to determine the form of the question by approving language to submit to the electorate. I've concluded my prepared remarks and am happy to stand for questions if the committee has any.
Thank you. I just wanted to clarify one thing. I did communicate with this campaign, just as I did with the other campaign, to make sure that if they had feedback on the ballot question, they were submitting it. And it's my fault. I should have known that the city junk folder or spam filter sometimes is more aggressive than it should be. So I should have checked that. But we did communicate verbally, and for folks to know, and this is before the campaign takes its time to address us, they had identified that there is a word used which is purchase the insurance. They had requested the word maintain be used instead of the word purchase. I had communicated to our city attorney, Susan Siegel, that I knew that the campaign would like a different word than the word purchase, and that they had referred to their original language presented when they were gathering signatures, which was the word maintain. The city attorney has proposed the word obtain instead of purchase. And so I think that's what I will move today, is replacing the word purchase with obtain, but knowing we probably are going to want to have more conversation with the campaign about this word obtain versus maintain. So I just want to say I'm open to that, but I think we might need to meet together after this meeting, if that's all right. So I think with that, I'm not seeing any questions. If the clerk could kind of clear out the question columns, that would be great from the council members. Oh, I'm sorry, Councilmember Cano.
I'm on the using the electronic management system here. I do have a quick question. Could the city attorney please speak to that recommendation to change from purchase to obtain? And did you say also maintain will be substituted with obtain?
I apologize. I just put something in my mouth. The campaign so the original language proposed by the city attorney used the word purchase in the title, and then it appears again in the actual language of what would appear on the ballot. The campaign identified that as the word they did not agree with, and asked the word purchase, and asked for the word maintain to be used. So it would read, proposal to amend the Minneapolis City Charter to require police officers to maintain liability insurance. The city attorney has proposed a little different word, which is the word obtain. So it would, for example, the title would read, proposal to amend the Minneapolis City Charter to require police officers to obtain liability insurance. I will just say there hasn't been conversation between the city attorney and the petitioners directly on this. So I just want to acknowledge that.
So my question was, could the city attorney please explain why she recommends obtain versus maintain? And I understand purchased is not desired.
Madam Chair and Council Member Cano, I think it's fine to take out the word purchase, but I think you need some word because the proposed amendment says that they have to have proof of professional liability insurance coverage, which means they have to get it. So actually what I'm recommending is the police officers to obtain and maintain continuous coverage, because both of those concepts are in the proposal. They both have to have it. And then I know an important part of their proposal is the requirement that officers must maintain continuous coverage throughout their employment, creating a new condition of employment, as you know, if you will, that if they don't have it, presumably they can't be employed, or if they lose it, that they will lose their employment.
Okay, so I just want to again acknowledge that the petitioners haven't had an opportunity to have more conversation with the city attorney and the clerk about the difference between the obtain and maintain and whether we could have both words or whatever. And the purpose of their time, the 15 minutes, was more about responding to the legal argument about whether this is a proper subject for the ballot. If they would like to make some comments about that, I want to just offer you the flexibility. You know, we want you to have the time that you need to explain. We can also, you know, there will be time between now and Friday as well to have additional conversation. I just want to give you my commitment to having some further conversation. So if you would like to, and do we need any assistance for the PowerPoint? No. Okay.
I'm good.
I wasn't sure.
Chair Glidden, Council President Johnson, and council members, my name is Michelle Gross, and I am a board member with the Committee for Professional Policing. And thank you so much for allowing us to present information on our police insurance amendment in preparation for your vote on placing our amendment on the ballot. And we're happy to answer any questions that you have at the end. Before we talk about the amendment, I want to talk about the current state. As it is now, the city is self-insured for police incidents. When a victim of police brutality or misconduct sues the city decides case by case whether to indemnify, that means cover, the officer. While the city is not required to indemnify intentional acts, they almost always do, though they once in a while refuse. A recent example is the Blaine Lehner case in which Officer Lehner kicked a handcuffed Luis Garcia in the face. The city refused to indemnify him. While that's good for the taxpayers, it could have been harmful to Mr. Garcia, as it would have been much harder for him to gain any measure of justice and to be compensated for his injuries through his lawsuit. However, even though the city wasn't going to indemnify Lehner, the city council voted to pay out $360,000 of taxpayer money to Mr. Garcia. Because the city is self-insured, funds for lawsuit settlements and judgments come from the city's self-insurance fund, which is part of the general fund. In other words, taxpayer dollars. However, even when an officer engages in conduct that results in a large payout, there have historically been no consequences for that officer because the officer is almost never disciplined. Therefore, there's no incentive for that officer to change the conduct that led to that lawsuit, and the only people who have consequences are the taxpayers. The police insurance amendment will require police officers to carry professional liability insurance. The city could, and we believe they should, cover the base rate of this insurance, but any premium increases due to police misconduct settlements and judgments would be the responsibility of the officer who caused the increase. There are a number of benefits to this approach. An officer who engages in misconduct that results in a premium increase will have a personal consequence for that conduct. This incentivizes that officer not to engage in this behavior in the future, applying a risk management strategy to policing that is not currently present. It also removes the element of politics in terms of who is disciplined and who isn't. Officers who don't learn that lesson and who continue to engage in misconduct will find that their rates increase, possibly to the point of being unaffordable, and in some cases, some officers may become uninsurable and thus no longer able to be employed by the Minneapolis Police Department. As the worst offenders leave, good officers will have a much better working environment. And this is not insignificant because staff engagement surveys in the city show that the police department has the lowest rates of staff engagement. So this is not insignificant. Taxpayers will experience a significant financial relief. Police leadership will have a powerful new tool for managing their staff. And finally, decreases in police misconduct will increase the safety of the community and improve police community relations. For these reasons, we feel the police insurance amendment is a win for all. Taxpayers get relief, officers get guaranteed coverage, a benefit they don't now enjoy, and better policing is incentivized and the community is safer. Many occupations use professional liability insurance to drive out dangerous practitioners. FBI, CIA, and other federal agents carry professional liability insurance, and their agencies reimburse 50% of the cost. Other professionals such as doctors, nurses, lawyers, all of these folks, even plumbers and beauticians, all carry professional liability insurance. It's not a new concept. Our amendment is only novel because it applies these same risk management principles to policing. Police officers themselves are interested in having this coverage. In a March 17th article in Reuters, the Fraternal Order of Police, which is the largest police union in the country, reported that sales of their professional liability insurance have increased 15% in the last year. And this is with officers purchasing the insurance on their own and paying for it themselves. Is the police insurance amendment legal? We say yes. We took a year to carefully craft our language in consultation with attorneys, labor experts, insurance professionals, retired police officers, and many community stakeholders to ensure that our police insurance amendment is not only legal, but that it would be effective and that it would not present additional barriers for people seeking justice after being harmed by police. The main state law that covers the issue of indemnification is Statute 466.07, as does the union contract, of course, speak to that issue. Under these statutes and provisions, the city is required to cover payouts resulting from lawsuits against police officers in cases where the police officer was acting within their role and duty. However, willful and malicious acts outside the scope of the officer's employment, those kinds of things are specifically excluded. In these situations, police officers would be liable, and the city is under no obligation to defend the officers or pay damages resulting from legal actions, and as we mentioned before, sometimes the city has chosen not to. By definition, misconduct falls outside the scope of employment. There is no moral, legal, or union contractual obligation that the city continue to pay out millions of dollars a year in bailouts for officers who engage in this conduct, and it may very well be misappropriation of tax dollars for the city to continue to do so. Through our research, we have found that policies available to federal agents and other policing agents that choose to purchase the insurance include coverage for intentional acts. Once adopted, our police insurance amendment will ensure that police officers are covered for acts of misconduct. Officers will have better coverage than they have now, and community members who have been harmed by misconduct will benefit from officers having guaranteed coverage. I want to say a word about the police labor contract. Our police insurance amendment goes into effect a year after passage, as you've already heard, allowing time for the city and the federation to negotiate the contract to determine who will pay the base rate for the insurance. And I want to say one other thing as well. In Ms. Siegel's opinion, she stated falsely that a note in our letter from our lawyer said that, and let me see if I can get her footnote correctly here. She basically claimed that we said that the union contract takes precedence over law. There was nothing in our letter that ever implied any such thing, and we do not believe that that's correct. I've made Ms. Siegel aware of that error. She has to date refused to address it, but nonetheless, we do not believe that the union contract trumps the law. In fact, it's the other way around. Let's talk about how this amendment might work in practice. There's a long history about how professional liability works in medical and other fields that we can draw from. In her opinion, Ms. Siegel states that there are a number of situations in which officers are sued when they have engaged in no misconduct at all, and we don't doubt that. We know that that's true. She also points out that in the situation of traffic accidents, there may be negligence, but not malfeasance, willful neglect, or bad faith. True again. In these instances, the city is required to defend and indemnify the officers and will do so as they currently do now. In instances of misconduct, the city has absolutely no obligation to defend and indemnify the officer, and as we have discussed, the city has sometimes chosen not to. In those cases, the insurance company would likely hire an attorney to defend the officer, and any payout would come from that insurance company. It's just that simple, folks. It's very easy to understand. Now let's talk about the financial aspects of this. Currently, judgments and settlements for police misconduct lawsuits cost the city about $2.5 million a year. You know, some years more, some years less, but that's running the average. And that doesn't include the hidden costs of legal fees for defending the city, paying officers and other city employees to be available to testify in court, depositions, etc. All the things that go into a lawsuit. This means we are spending about $3,000 per officer per year in judgments and settlements alone. And I'm talking about every officer here, including the ones that never cost the city 1 cent. These costs come from the city's self-insurance fund. In other words, we are literally budgeting for police misconduct. Because this kind of insurance has not been available in Minneapolis before, we don't know with certainty what the cost will be for it. However, our research indicates that the base rate for these policies will likely be in the range of $300 to $400, probably on the higher end of toward $400 per year. And that's because we know this from what officers purchase on their own, as well as the federal agents' insurance policies. If the city decides to pay for this base rate, and again, we hope that you do, this will still reflect a very significant savings over the current self-insurance scheme. Even if the initial costs would be higher, and we don't believe they will be, over time these costs will decrease as risk management strategies are applied that reduce the rate and number of incidents, and as police officers self-select to leave the department or become uninsurable and enforced out. We do expect that just as the base rate for professional liability insurance differs for various physician specialties, some police assignments will carry higher or lower base rates. Again, we would encourage the city to negotiate with the police union to cover the various base rates for this coverage as a new benefit for the officers. Minnesota statute, let's look at what I'm going to talk about now is the city council's obligation. Minnesota statute chapter 410 indicates that the city council has a ministerial duty to place our proposed amendment on the ballot since our petition has been certified as having sufficient signatures. There are a few exceptions that have been carved out through various lawsuits. These are if the amendment is in conflict with state or federal law or public policy, which really means the collective intent of state law, or if it is not a proper subject for the charter. In these exceptions, the council may decline, but doesn't have to, but may decline to place an amendment on the ballot, but may also choose to place it on the ballot and allow the process to play out in the voting booth and in the courts later. We already know that the amendment is a proper subject for the charter, as it is just a continuation of Minneapolis Charter paragraph 7.3A2, which outlines the requirements for police officers in Minneapolis. So we already know it's a proper charter subject. Our amendment clearly does not violate public policy. In fact, it represents an improvement over the current situation. Finally, our amendment is not in conflict with state or federal statutes, as I've already outlined. Your other obligation is to submit ballot language, and we've provided you with our, apparently, however, through an email snafu, you didn't see our suggested language. We do prefer the term maintain, and the reason we prefer it is because it implies that the person will carry it throughout the course of their employment. And so we do prefer that term maintain. We think it's a more proper term. But basically, that's your other obligation, is to select the language and put this thing on the ballot. This has been a long road. Educating the public and collecting over 15,000 signatures to get this on the ballot was no easy feat. The road has been made even longer because the city has violated law and practice in putting us through delay after delay, illegal delay, in processing our amendment. We urge you to end these delays by voting to place this police insurance amendment on the ballot. You will not be in violation of Minnesota Statute 410 by placing it on the ballot, but should you choose to subvert the will of a significant portion of the population by voting no, we are prepared to go to court to seek an emergency action to get this measure on the ballot. Not only are we prepared to prove the legality of the police insurance amendment, but we will also bring in the many violations of law and practice the city has committed in its lengthy delay of processing our amendment. The city can avoid all this by voting yes to place the police insurance on the ballot. It is time to let the voters decide. Thank you.
Thank you, Ms. Gross. Anything else? Not seeing anything. I guess I could ask. Sure. And I'm going to ask the clerk if you could clear those speaker things from the, okay. It's just the speaker queues. We have the old speaker queues up.
And Mr. Bicking is also available to answer questions.
Maybe something's
as well.
on. So if folks can just let me know.
Mine isn't.
I apologize. We have the speaker management system, and I'm somehow stuck in the last
It's fine.
thing. Okay. Any questions from council members? Councilmember Cano.
Thank you. Thank you, Madam Chair. I would like to know from the committee sort of the impact that you think this would have on our police force in general. I know that I've heard some people worry that this is going to impact everybody negatively, or that it's going to lump everyone into one category and sort of, punish all the officers. So I'm just wondering if you could talk a little bit more about the differentiated approach and how you think this would really zero in on specific problems that we have, repeat problems within our workforce.
Thank you very much for that question, council members. This is not a punishment of the police. The great majority of police officers never have a lawsuit against them in their career. The great majority of police officers will pay the base rate for this insurance and have guaranteed coverage, which gives them the assurance that they are covered in any case, not just in those cases which are required by 466.07. So for the good officers, it is a benefit that they do not have now. For those officers who have a problem controlling themselves, following policy, following the law, they will be affected by this, definitely, in the sense that they will now have the disincentive of their insurance rates going up if there's a sign of significant risk. That sign may be previous lawsuits. What we have found is that in nearly every case where there is a very significant lawsuit against the city, that officer has a history which has already shown a high risk. And most of the settlements, most of the things that would cause the insurance rates to go up are the cases that will have identified those officers. Our police union president has said, well, it's like basketball. If you don't have enough fouls, you aren't playing hard enough. These are not fouls, and that indicates a cavalier attitude that is unfortunately too prevalent among some of the officers. And it's an attitude which says, yes, we can break the rules. And it's an attitude which leads to the kind of very vicious behavior that we sometimes see. This is not a game. The rules in policing are laws, and the police officers must follow those also. So we need to change a culture which says it's okay to violate people's rights. And when officers see a consequence for that, which they do not right now, and one of the reasons they don't see that consequence is because when the city takes on the defense of all officers, regardless of whether they're required to or not, it means the city has an incentive to say, oh, that's a very good officer. He has a very good history. And so we find that the officers who come in front of your council, and you have these private meetings every couple of weeks, those officers that come in front of you are being defended by the city. They are getting no consequences. When there are consequences, people behave better. And when there is the possibility that they will lose the ability to work for the city, that will be, in some cases, a very positive development. Thank you.
Yeah. And I'd like to add, if I could, please. Again, as Dave points out, it's a handful of officers that are truly problematic, but there are no consequences for those officers. The Office of Police Conduct Review, for example, at the end of the first quarter of 2016, had in those 3.5 years taken in 1,323 cases from members of the community. One case out of all of those cases in 3.5 years has been sustained and disciplined. One. This is not a way to address police misconduct. In fact, it sends a very powerful message that you can pretty much get away with anything you want to get away with. We have one officer on the force, Tyrone Barzi, who has had 7 lawsuits in a period of about 2 years. And his lawsuits have cost the city $380,000. Yet he remains on our payroll and has no consequences for that conduct. Again, not a way to address a very serious problem. And it's not just about tax dollars. It is about tax dollars, but it's not just about tax dollars. It's about real people who get really hurt. There are people in our community that are suffering, that have long-term injuries, that some people are killed. It is about that. And so whether we talk about dollars and cents and all of this other stuff, and I do believe our amendment is cheaper, is less expensive for the city. But even if it wouldn't be, there is a cost for people's lives and bodies. And that's a significant expense that we have to not ignore. So thank you.
All right, we had one other question from Councilmember Yang.
Thank you, Madam Vice President. Ms. Gross and Mr. Baking, you both are guessing as to how much it would cost for police liability insurance. Is that the case?
I wouldn't say we're guessing. I'm saying we researched it in our best guess, because there isn't, it would be as if we never had auto insurance and then the state or the city council or somebody said, now you have to have auto insurance. It wouldn't be known at that time what it would be, but we'd have a rough idea of what it would be. And we believe it will be in the $300 to $400 range, because that's the typical policy cost. And I've checked around a number of cities around the country.
But you just don't know that, right?
Well, you couldn't know with certainty, and nobody ever could until the market opens. And frankly, it will be a variety of costs. We expect that various insurance companies will come in and they'll offer different kinds of insurance. As long as the insurance meets the basic parameters, then officers are free to add other parts to the insurance, other riders and things like that, and could choose to purchase a more expensive plan. In fact, the FBI agents have choices of a few different plans that they can select that have more coverage and less coverage. They have a minimum that they have to select, but then they can choose things and pay a little bit more money for those. So, it's the same thing that you run into when you purchase your homeowner's insurance, your car insurance. It's going to be a competitive market, and different insurance companies will offer different offerings. And as long as they meet the minimum threshold, then the cost will vary based on the company. So, but again, our best research shows that it would be between $300 and $400, probably closer to $400, like it was running around $370 to $380 was the average that I was getting when I did we did significant research on it.
May I add just briefly? The costs are, of course, an issue, and of course, the costs of the bad policing that we have right now are an issue that you face in the Ways and Means Committee quite frequently. But cost is not the issue before you today. The issue before you today is whether this amendment is legal. And the standard on this is that you start off with a ministerial duty that requires you to vote to put this on the ballot, with very narrow exceptions. Those exceptions have been opened up by the courts only for the purpose of avoiding the frustration and futility of an election that will immediately be overturned. As a result, the only exception to your being required to put this on the ballot is if you are certain beyond a reasonable doubt that this amendment is illegal.
And illegal, by the way, would mean manifestly unconstitutional,
right,
is the language they typically use.
Or specifically violating a state law. At this time, Susan Siegel put out her opinion at the very last, the afternoon of the last possible day, 8 weeks after we filed. We understand that in early June, she was telling the council that she could have this available in a week. That has stalled this long. We have had 3 working days to respond to her legal opinion, and I apologize that our letter and our annotated thing got to you so late after the end of the working day. But unless you feel that you can just simply rely on Susan Siegel's opinion, or you've had the time to really evaluate this for yourselves, it is against your ministerial duty to vote to not put this on the ballot. This is a very serious question. It's a legal question. It's a legal responsibility of this council. And though we may be quieter than 15 now, we are just as determined. We have the means, the determination, and the lawyer to take this into court immediately if you vote to take this off the ballot. The people need to vote on this.
Okay. And I thought Councilmember Kama was this one last question for the campaign.
Madam Chair, I actually am finished with my questions. I would like to make the motion to move the resolution forward to submit this as a ballot question.
Okay, so Councilmember Kano has made motion. Councilmember Johnson.
I would like to speak on that when.
Okay, I will let Councilmember Kano.
City attorney?
Well, we were, but Councilmember Kano has made a motion. She's allowed to make her motion.
If you would like to have the city attorney take the podium, I would be willing to hold my motion to have her speak.
Thank you. I appreciate that. So we will know that Councilmember Kano has made her motion, and then Councilmember Johnson has put himself in queue. And I think if we could clear off the speaker list, so we've got the motion in queue. And Ms. Siegel, if you want to go ahead, then Councilmember Kano has said we will take up her motion as soon as you've had an opportunity to give us your overview.
Here we go. Madam Chair and members of the council, thank you. I'm not going to repeat the legal test. I think we're all in agreement on the legal question before the council on this proposal. Real briefly, the proposal requires officers to obtain and maintain continuous professional liability insurance coverage. The proposal states that it must be the primary insurance for the officers. It must include, not limited to, but include coverage of willful or malicious acts and acts outside the scope of the officer's employment. It does allow the city to reimburse officers for the base rate of coverage, but it is prohibited from doing so for any additional costs due to personal or claims history. As Ms. Gross stated, the city has chosen to self-insure for its statutory obligations to defend and indemnify. The city has the authority now to go out into the private insurance market and to buy private professional liability insurance to cover its police officers if that is a more economic option. My assumption is that it is not a more economic option for the city, and that's why the city has chosen to self-insure. But the city does have that power now.
you do not need a charter amendment or any other authority to do that. And again, that's not the question in front of the council anyhow. The defect in this proposal is that it's just in plain old conflict with state law. And state law imposes a duty on cities to defend and indemnify their employees, all their employees, not just police officers, but all their employees. Minnesota statute section 466.07 says cities shall defend and indemnify their employees provided that they were acting in the performance of their duties and not guilty of malfeasance, willful neglect of duty, or bad faith. And as the petitioners pointed out, when we have come to the conclusion that employees have engaged in malfeasance, willful neglect of duty, or bad faith, we have made a recommendation to this council to not defend or indemnify them. There's another provision also, section 471.44, that relates specifically to law enforcement officers. And that imposes a duty to provide a defense to law enforcement officers against lawsuits for any type of damages in connection with an arrest. And the duty of defense there includes paying all costs of and expenses of defending the suit, including witness fees and costs of legal counsel. Now, both of these provisions preempt the police liability insurance proposal here. And I think part of this, because I've honestly been trying to understand the difference of opinion here, and I've had some trouble doing that. In the written materials that the Committee for Professional Policing have put forward, they say that this charter amendment proposal would only apply to acts that the city is not required by state law to defend and indemnify employees for. But that's not what they've written. They could have written it that way, but they did not write it that way. What the proposal states, as I said before, is that it has to be the primary insurance, and that it must include, not that it is limited to, it must include coverage for those kinds of acts that the city does not have to defend and indemnify officers for. It states must include coverage for willful or malicious acts and acts outside the scope of the officer's employment. And I think that's maybe where some of this difference of opinion comes from, is thinking that their language says one thing when in fact it says something quite different. Now, the other thing about these statutes, of course, general state law supersedes any city charter provisions or any city ordinances, but the state has doubled down with these two statutory requirements and has explicitly stated that they are exclusive of and supersede all home rule charter provisions. And section 471.44 also supersedes any other general law of the state of Minnesota. So it's pretty crystal clear. Now, how does it conflict with these two provisions? When you're talking about defense and indemnity, that's what insurance policies do. They provide defense and indemnity. So those are interchangeable words, really. No, absolutely not. Okay, I hear voices in back of me disagreeing. So what I did this morning after reading the response letter from the petitioners was I went online and Googled police professional liability insurance. And after going through a few ads that were there for defense lawyers, the first insurance company site that popped up was for travelers. And this is what they said that they provide insurance for. And you will note that here, about halfway down the list,
is defense for claims or suits. So that's what insurance is. You're providing defense and indemnity. Now, the petitioners do include in their proposed amendment a proposal, a statement that the city may reimburse officers for the base rate of coverage. And that helps their cause. But it goes on to say that officers must be personally responsible, and it prohibits the city from paying for any additional costs due to personal or claims history. And professional liability premiums, just like your home insurance or your auto insurance, once you make a claim, guess what? Your premiums are going to go up. Your experience rating is going to go up. Close to half of all lawsuits that our office defends on behalf of police officers are dismissed in the officer's favor. Typically, that's after all discovery is completed, there are depositions taken, discovery is completed, and a summary judgment motion has been filed, and perhaps it's after trial. That's hundreds of hours of attorney and paralegal time, expert witness fees, etc. That's a substantial cost. No insurance company in the world is going to continue you at $400 a year after paying out for that. And I think that the committee, as much as acknowledges that in their letter, that actuaries may increase premiums. So these are suits where the officers have not engaged in any unlawful conduct at all. Lawsuits are settled for a variety of reasons, as you know from having sat in on closed counsel sessions where we've provided you with our reasons for settlement. Sometimes it's because there is liability and an officer has violated the policies and procedures of the police department, and the police department has opened an internal affairs unit investigation. And when that's happened, officers should be disciplined and ultimately terminated if they're violating the policies and procedures of the police department or violating the law. But there are a lot of reasons why cases are settled, some of which have absolutely nothing to do with whether an officer is actually engaged in malfeasance, willful neglect, or bad faith. And in all of these situations, officers would be subject to an increase in insurance premiums that they would have to pay for out of pocket. And that is how it conflicts with our statutory duty to provide defense and indemnity. Now, second independent ground here, let me catch up. Yes, is the Public Employee Labor Relations Act. City's police officers, as we all know, are represented by a union. The Public Employee Labor Relations Act requires employers to negotiate in good faith over mandatory subjects of bargaining. What that means is that we cannot make unilateral changes in a union contract that would violate the state public employment labor relations law. Now, there are two sections of the police contract that have been in various iterations, different words, but have been in the Police Federation contract since at least 1986, which is as far back as we could easily go in our office. One, Section 26.1, the first one, which basically parrots state law with regard to providing a defense and legal counsel. Cities shall provide legal counsel to defend any employee against any action or claim. Again, it basically repeats our state law obligation. And then 26.3, which states that the city may at its option go out and buy private insurance. So even the union contract recognizes the city's right to do that right now. But then it goes on to say that the city shall pay all premiums for such coverage. So that is at odds with what this charter amendment proposes. So that provides an independent ground, this conflict with the Public Employment Labor Relations Act, for saying that this proposal, while I know it's very well intentioned, is in conflict with state law. As such, it's not a proper subject to be placed on the ballot. And again, I don't think it should be placed on the ballot. And happy to answer any questions.
I'm not seeing council members getting queue. I'll just note Councilmember Cano has a motion that is before us. And I would invite her if she would like to speak to her motion. And then we have a queue with a couple council members in line.
Thank you, Madam Chair, and thank you to our city attorney for walking us through a detailed explanation of her position. You know, I'm really struggling with the legal framework that we're currently operating under, which continues to dispose of the lives of African American people, Latino people, Indigenous people. And as a policymaker, I think it's very important for us to think about our role in allowing our community to be a part of the decisions that we make and ensuring that we are taking into consideration the multiple legal opinions that have been presented to us today and throughout the last weeks as this issue has come forward. I do want to personally apologize to the community for having this process taken so long. I know that you all submitted your signatures weeks and weeks and weeks ago, and yet you're still on the same timeline as the minimum wage issue. And to me, that is a disservice to our residents. That makes it very difficult for us as policymakers to have enough time to weigh in on the issues with proper diligence. And I know that the community did not have enough time to respond to our city attorney's opinion, and yet you made it happen. You know, it's very hard to expect somebody who's working on a volunteer basis to put together these kinds of responses. But I'm going to say that after working with so many different individuals and experts outside of City Hall on this issue, I have come to believe that this is appropriate for our city charter. I believe that if we have enough political will to stand up together to say that it is appropriate, we can allow it to move forward. And that's one of the reasons why I'm making this motion today to move forward the police liability proposal as a ballot question. And also because I think that the times that we're currently living in, where we are struggling to come to terms with the aftermath of the Philando Castile shooting, which has put Minnesota on national news headlines for all the wrong reasons, we need to create a new system because what we have now is not working. And so I would much rather move in that direction than be locked into a series of legal opinions, which again, there's many legal opinions here, and continue to worry about who is going to be killed next in our community. And so on that, my position is that I believe that this is appropriate for us to take on as a charter amendment, and I believe that our residents should be allowed to vote on this issue in November, and that's how I would like to move this forward. Thank you, Madam Chair.
So we have Councilmember Andrew Johnson, who put up his little red thing, and then Council President Barb Johnson.
Thank you, Madam Chair. With these citizen petitions for charter amendments, I take them extremely, extremely seriously and do my due diligence reading over the opinions and considering the legal arguments before us. And I know I mentioned to the organizers I had a few concerns and asked them if they could respond to that. They have, and I understand that we are on a tight timeline, and they have provided this annotated copy. And I want to let them know that I have not had a chance to read this yet, and I do plan on doing so. And so I'm going to take the rare step, which is my right at committee, to abstain from voting on this issue until I have had a chance to go over this. I have a responsibility to do that. I owe it to you, and I appreciate you responding to this. So I will go over that, and then I will make a vote either yay or nay by Friday on this. And if I have any questions for either Ms. Siegel or for the petitioners, I will let you know. But thank you for providing this, and I understand the tight timeline and constraints, which require my abstention today so I can thoroughly review this. Thank you.
So Council President Barb Johnson is in queue.
Thank you, Madam Chair. I would move a substitute motion that the city clerk is directed to not submit the proposed charter amendment as a ballot question to the county auditor for placement on the ballot for the November 8th, 2016 general election. And I just would mention, if I may, that I think our city attorney presented a reasonable and thoughtful analysis of this issue, and I appreciate the work that's been done on this. So I'm going to move that it not be put on the ballot.
Okay. So and I always forget a little bit what I need to do. So there's a motion to substitute before us, then we need to vote on whether to substitute and then vote on the underlying motion, whatever. Is that correct?
Madam Vice President, the substitute that's been proposed is essentially a motion that would be the opposite of the motion that's on the table, which would be an improper motion. The action to be taken is to vote on the motion that was put forward first, because the amendment offered by substitute essentially is one that makes the adoption of the motion the opposite or the negative of the main motion. It needs to be offered as a separate motion.
I see. Okay. So we will vote on Councilmember Cano's motion, and then we would take up the Council President's motion as a separate motion. Thank you very much. I'm glad I asked. All right. So I am not seeing further comment on Councilmember Cano's motion. So all in approval, please say aye. Aye. All opposed?
No.
No.
Are they killing black men in this country? Y'all let them do it, and they don't even have to have insurance to do it, and we pay for it? 850 cops in this city. 50 of them live here. Shame. Shame. They don't even live here and they kill them.
Thank you, sir. So there is now a separate motion in front of us, which is Council President Johnson's motion. Any discussion on that motion?
Can you please restate the motion?
Does the clerk want to help restate the motion?
The motion pending would be the adoption of a resolution that would essentially concur in the findings of the city attorney that this is not a proper subject to submit to the ballot, and directing the city clerk not to submit the question to the county auditor.
Okay. So, Councilmember Cano? All right. Any discussion on the Council President's motion? I'm not seeing any. All in approval, please say aye.
Aye.
Aye. All opposed? Nay. Okay. So we had a presentation from, okay, there's been a request for the roll call on this, and we always do that as a courtesy, so the clerk will call the roll.
Councilmember Gordon is absent. Cano.
No.
Reich.
Aye.
Bender.
Aye.
Andrew Johnson.
Abstain.
Yang.
Yay.
Quincy.
Aye.
Warsami.
Aye.
Fry.
Aye.
Palmisano.
Aye.
President Johnson.
Aye.
Chair Glidden.
Aye.
There are 9 ayes, 1 nay, 1 abstention, and 1 absent.
Okay. So I'm now just going to make a motion to receive and file the 2 city attorney opinions that were presented before us as well as any presentation materials that were presented from the committees to us. So those are part of the official record. So all in approval, please say aye. Aye. Opposed? We have a third item, and I am actually just going to move approval of this item. This is the strategic.
I'm ashamed. Two black people across this country, and you're allowed to do it. You're allowed to do it. You let them do it. You let them do it. You don't even live here. You, city attorney, you work with them.
All right.
You work with them. It's in your vested interest to make sure they don't have this. Don't shake your head. Shame.
Thank you, sir. Thank you, sir.
Brown people. Shame.
Thank you.
Shame. Who's on that? Who gets affected by the police? Who gets pulled over? Right. Huh? How many times you guys
Are we going to sit and listen to this?
All right. I'm going to ask if you could please leave the chamber so we could finish. Yes, sir.
That's what I want. Shame.
Thank you.
I'm afraid when the cops pull me over.
Okay.
They can kill me. And then the city will pay for it.
Okay.
The city will pay for it. I live here.
Thank you,
They
sir.
don't even live here.
Thank you, sir. Thank you,
They don't
sir.
even live here.
All right.
Shame on you. It's time for some of y'all to go. It's time for y'all
So-
to go. Let's go.
All right. We need to be able to finish our business. Thank you. We have a motion to receive the report on the. Sir, I am asking if you could please either be able to allow us to finish our meeting. Okay? Thank you, sir.
I want to see you or your kids. What do you think of that? I'm living in Minneapolis. I want to address the people that I elected to represent me.
Okay.
I am saying 50 cops live in this city.
All right.
50. We pay for them. We pay for their mistakes. We pay for them to live. And y'all dissed us on 15 an hour. And now y'all, come on. Racism. This is racism.
All right. Thank you,
At
sir.
highest level.
Sir, I am asking if you could please leave now. Thank you.
If you're asking, I'm mistaken. If you're ordering me, I'll leave.
Okay. I can do it that way, too. I didn't want to.
That's what you want to do. I'm
So, all right, to everyone, I do respect that we have very strong emotions here. Thank you, but we need to be able to finish our business, and I'm asking. Okay.
I want the police to have some type of
Sir, you are on the record with having expressed that to us very, very strongly. I'm going to ask our security officers if you could help this gentleman leave, please.
They can do whatever the hell they want to. And that lady right there, you sat there and sit there and tell them it's not okay. We know you defend them. We know you defend them. So, nobody better not touch me. I ain't touched nobody. I ain't said nothing. I'm just speaking my truth. You guys hurt people. You hurt people by making bad decisions. Right. That's right.
All right, we have one last item before us, and I am going to ask for a vote on this, which is to receive and file the workforce assessment and diversification staff directive, as well as approving the enterprise workforce representation goals of hiring 41% of the city's workforce as people of color by 2022 and 45% of the city's workforce as women by 22. So is there discussion on that motion? This was the presentation we received last cycle. All in approval, please say aye. Aye. Opposed? What is your, Councilmember Johnson?
Thank you, Madam Chair. I do have a staff direction related to item number 3 now that it is approved, and I have worked with staff on this. It is simply moving that staff of the Department of Human Resources in conjunction with IT be directed to develop a website that will include quarterly workforce dashboards and annual enterprise EEO plans and a report back to the committee of the whole by the end of Q1 on progress of those items. I have worked with the city's coordinator's office on this language and also the mayor's office on this.
Okay, so Councilmember Johnson has moved to staff direction, which is about translating the work of human resources to an accessible website. Discussion on the motion. Seeing none, all in approval, please say aye. Aye. Opposed? That item is approved. And then finally, we do have on our agenda reports of committees. I don't know if there are key items that folks feel like they need to mention. Otherwise, I would ask that we be able to just adjourn our meeting. So I'm just looking to committee chairs if there is something you want to alert us to. And I'm not seeing anyone raise their hand. So with that, we have concluded our business and we are adjourned.